All right, I believe we have everybody here for the next case, which is People versus Magnant and People versus Davis. My understanding is that Mr. Tpta will be doing the argument for the defense, although Mr. Saman will answer questions if we have them for him about his client. And this is a 15-minute mini oral argument on the application. Mr. Tpta, you may begin. You may reserve time if you would like, but you will be charged with trying to do that yourself.
Thank you. Madam Chief Justice, honorable justices, may it please the court. My name is Wally Tpta, and I represent the appellants in this case. And as the court correctly said, Mr. Saman is also present and is available to answer questions. We'd like to reserve, if we could, 5 minutes for rebuttal. And we may split that rebuttal time, that is Mr. Saman and myself may split the rebuttal time if the court allows. This case involves a question of statutory interpretation of the Tobacco Products Tax Act and whether a scienter element is required as to each element of the crime in order to ensure that innocent conduct by citizens is not prosecuted as criminal conduct, and also involves whether the appellants are properly, as individual employees, are properly found within the constricture or definition of the transporter requirement in the Tobacco Products Tax Act, given the overall scope of the Tobacco Products Tax Act, the Tpta.
Okay, we are going to rewind to where we were, which was you were beginning to present your argument, Mr. Tpta. You have 13 minutes and 36 seconds on the clock, and you may continue.
First of all, I'd like to apologize to the court. I don't know what happened, and obviously I'm a low-tech kind of guy, being as old as I am. So I had my IT person here, and we practiced this, and it worked. But anyway, so my apologies.
We've all been there. Don't worry about it. We've all been there.
Thank you. Thank you very much. So this case involves a matter of statutory construction of the Tobacco Products Tax Act and whether the legislative intent in this case was to apply a scienter requirement to each of the elements that are in the act, or only, as the state contends, to the possessory element. Appellants believe it's absolutely essential that the scienter element apply to both the actual possession or transport of the cigarettes, in addition to the fact that that possession and transport must be contrary to this act in order to avoid criminalizing otherwise innocent conduct. The case also involves whether the employees, the appellants as individual employees of the Keweenaw Bay Indian community, are subject to the transporter definition and whether they are subject to the licensing requirements of the Tpta as a result thereof. And finally, whether, if they are, whether the statute provides sufficient notice to people such as Mr. Magnant and Mr. Davis that in fact they are subject to the requirements of the Tpta. Case law from the United States Supreme Court, case law from this court, the legislative history of Section 3, MCL 205-428, Section 3, the legislative history and the legislative amendments clearly indicate to this court that this is not a statute that is imposing strict liability, but rather imposing a scienter element or a scienter requirement. The court need not guess about legislative intent in this case, since the legislature saw fit in 2009 to amend or add, I should say, to the statute adding a misdemeanor provision specifically requiring knowingly transport, possess, etc., contrary to this act. And therefore, it's clear that the scienter requirement of knowing transport, possession contrary to this act is in play here. That is consistent with this court's findings, this court's holdings in Rambin, which held that scienter is a default provision or a presumption in every criminal statute unless strict liability is imposed, which it's not. And more importantly, that the fact is that it should be applied to each element of the offense. That philosophical approach is also held by the United States Supreme Court. And when this court discussed those concepts in Rambin, it cited to various Supreme Court opinions, including Excitement Video, which talked about that very fact, that the elements have to have scienter. Each element is subject to the scienter requirement, subject to a jurisdictional issue or a punishment issue, enhancement punishment issue as an element. But the short version is that
Mr. Ptsa, let me interrupt you. Let me interrupt you so I can make sure we have time for questions. And you didn't ask me for advice, but your video continues to freeze, and I'm worried you're going to get locked out again. So if you are interested, I would turn your video off and just keep your audio on, and that will make it more likely that you don't get frozen out of the meeting again.
Okay, Your Honor.
Just a piece of advice from somebody who Zooms all day every day. And we will start our questions with Justice Bernstein.
Counsel, good morning. And just to make you feel better, you know, you and me with technology, I'm like using a phone, so don't feel bad for a second. The question I have for you is, I was somewhat moved by Judge Krause's dissenting opinion. And, you know, I have to say that gets me to take a second look at this. But can you help me kind of in terms of certain components of this, basically addressing the fact that, you know, ultimately, you know, if I'm not mistaken.
Justice Bernstein, let me interrupt you for a second because I think we might have lost Mr. Ptsa again. Are you there, Mr. Ptsa?
Okay.
I do not see Mr. Ptsa. Let's wait just a few seconds to see if he rejoins the meeting. Sorry to interrupt you, Justice Bernstein, but he couldn't hear you, so I figured may as well.
No, of course, of course. I love it. You have two people who neither one, he doesn't have video and I don't have video, so. It's a perfect fit.
Just can't. I can't even tell you how sorry I am. It's just embarrassing. I'm totally embarrassed.
It's actually really not. I don't know how. I would love to make you feel better because we've all been here, and I feel terrible for you right now because I know how stressful this is. And please don't worry about it. I do think if you're worried it's going to happen again, if you want to turn your video off, that's usually a good way to not get locked out. If you want to just.
I'm on a laptop now, and I've just changed everything around. So I tried to be high tech, and it didn't work very well. So apologize to everyone.
Okay, well, we're gonna, Justice Bernstein was asking you a question, and I'm gonna turn back to him to start over because I don't think you heard much of it.
I'm sorry. Thank you.
No, Chief, thank you so much. And counsel, please don't feel bad. Like literally, blind people can't use Zoom, so you're 10 steps ahead of me. So we totally empathize and completely understand your situation. So don't even think twice about it. So I do have, and again, you're talking to a guy who, just so you know, I'm using a phone. So if that makes you feel any better. I should
have just used my phone. It would have worked better. That's for sure.
That's what blind people are doing through this pandemic. But counsel, let me just ask you. So I am sensitive to Judge Krause's dissenting opinion, you know, in terms of the reasons that she kind of set forth in her opinion. But then I look to the facts of this case, and maybe you can kind of, you know, help me kind of in terms of this, because I was sensitive to what Judge Krause wrote. But the question I have for you is, in this situation, you know, the fact pattern kind of creates some challenges in this regard. Your client's your clients basically lied to the officer that, pulled them over. They indicated that there were chips in the back of the truck. Then they indicated that, then when they went to open the truck, they said, hey, I'm just the worker. So it was clear that they had a certain sense of what they were doing, and they had a sense that perhaps what they were doing wasn't legal. So if I were to try to reconcile what Judge Krause wrote with the facts of this case in terms of the conduct of your client, how would I do it?
Your Honor, there's, I think, a couple of things that you could do. Number one, and Mr. Salem Saman, my co-counsel, perhaps should speak to his client's knowledge or lack thereof with respect to the court's question. When the statement was made with respect to chips or supplies, the trooper did not remember who said what. And so, number one, there's not any lying that you can specifically attribute to either of those individuals with respect to the status of, what was in the back of that van, in fact, or in the back of the trailer. In fact, as to, Mr. Davis, my client, I don't think there's any showing whatsoever that he knew what was in that trailer, never laid eyes on what was in that trailer, etc. But I think that with respect to the knowledge issue, regardless of whether the state can prove knowledge or not, the question becomes for this court whether the scienter element applies to that contrary to this act, which is the court's concern with respect to knowledge of what was in there. In other words, were they somehow aware that they were transporting cigarettes? Were they somehow aware that they were acting contrary to the act, as opposed to merely possessing cigarettes, which of course is a totally innocent act and totally innocent conduct, and certainly would not be proper to criminalize conduct that is innocent. The criminal law, of course, is meant to punish the guilty, not to punish the innocent. And when one starts to punish innocent conduct, totally innocent conduct, without any intent or without any knowledge of wrongdoing, we are violating basic tenets of criminal practice, criminal jurisprudence that have been in existence for hundreds of years. And so what I'd submit to the court is the question is not so much whether they had knowledge or not, but whether that scienter element must be applied to the possession or transport contrary to this act, which of course is that element, that contrary to this act element, is the very element which makes the conduct criminal. So the teachings of Rehife and Layperson from the U.S. Supreme Court, which relied on excitement video, which this court relied on in Rambin, and which this court in Rambin also recognized the fact that each element of a criminal offense is and must be subject to scienter of some sort, is implicated. And that, I think, is the key position, that the key point that we make, and that is supported by the fact that the legislature in this case amended the statute to include knowingly in the misdemeanor provision. And so to satisfy bedrock and accepted principles of criminal law, you only want to prosecute guilty people, not people who are engaging in innocent conduct. And you need the confluence, if you will, of both the evil mind and the evil act. And without this court directing the lower court to apply that scienter element, the knowledge element, to the fact that the conduct was contrary to the Tpta in some way, in this case, because there was not a transporter's license. We violate those basic tenets of criminal law. We violate those basic needs to protect innocent conduct from being prosecuted. And the government, or the state in this case, is comfortable saying, no, just you can be prosecuted and we're going to vet it. Well, of course, there's the case law is legion about the appropriateness of that kind of logic or that kind of reasoning. But the state is...
Counsel, I'm going to interrupt you because we have a lot of people who might have questions.
I'm sorry.
Do you have additional questions?
No. Thank you very much, counsel.
Okay, Justice Clement.
No questions.
Justice Kavanaugh. Justice Kavanaugh?
No question. Sorry, I thought I was unmuted.
No. Justice Welch?
Yes, I actually have a quick one. Thank you. I'm just wondering, I'm trying to get my head around this knowledge element. If an individual, I want to just present a quick hypothetical. If an individual were to go out of state and pick up 50 cartons of cigarettes from a manufacturer or wholesaler that the driver of the truck knows they're unlicensed. They know out of state that they're unlicensed, but don't realize they themselves need to have a license. Is there a violation of this statute?
I'd submit that that would indicate a lack of knowledge by the driver as to any wrongdoing, or that that person was acting contrary to this act, and that the appropriate prosecution would not be with respect to the driver, but with respect to the individuals who were directing that driver, if it was an employee situation. However, it might change if the individual was acting in his own business, because then one would be presumed that if he was picking up cigarettes, he would know and have to know that he was licensed, and therefore there would be some indication that his conduct would have been contrary to this act. That is, that he would have to be licensed. So, you know,
I think Justice Welch is satisfied. Let me just make sure everybody has a chance to ask questions. Okay, counsel. Justice Zara?
Questions at this time, thank you.
Justice Viviano?
Counsel, aren't you getting close to making an argument that your client, their ignorance of the law is what allows them to operate without getting a license? In other words, if they had only been made aware of this law, then they couldn't transport without a license?
Justice Viviano, that you may be right that it's getting close, but it's certainly not ignorance of the law. It's just ignorance of a fact that is necessary to impose criminal liability in this case. So we're not arguing that we don't know about the law. That's not the argument. We just simply are saying that the appellants in this case were not aware of the facts that would make their conduct contrary to this act and thereby impose criminal liability. And that's exactly what
they weren't aware that they were not licensed? There's
no proof that they didn't have a license. That's true. They did not have. That's in the record. But there's no indication that they were aware that they needed to have a license, and that therefore they were knowingly acting contrary to this act as employees of the Keweenaw Bay Indian community. And the case of both the United States Supreme Court in both cases, Layperson and Rehife, said and indicated exactly and addressed the question that you just asked, Your Honor, and that is that this is not an ignorance of law defense. It's an element that's required to impose criminal liability. It's the element that requires them to be aware that they're doing something wrong, not necessarily in violation of a criminal law, not necessarily in violation of a specific tenet or a specific section of the Tpta, but at least they had some awareness that they were acting wrongfully or in, to use the legislature's words, contrary to the act. And there's no such showing. And again, Rehife and Layperson directly discussed the court's concern and said, no, lack of knowledge of that element, because it is an element of the crime. It's clearly an element of the crime. The question becomes whether you have to have that knowledge of that element. And Layperson and Rehife both said, yes, you do. You have to have knowledge of that element. And Rambin, obviously, this court's opinion talks about the fact that each element of the crime is subject to scienter requirements. I don't have a timer, so I don't know how much time I have, and I apologize for that. Can someone just...
The timer is on the screen, and you are out of time, but I'm going to see if anybody has any additional questions, including Justice Viviano. I don't know if you wanted to follow up or if you were satisfied.
Well, I think the distinction with the cases you're citing is that there was a knowledge requirement more specific to each of the elements. And here we don't have the word knowing, and so we're having to determine whether this is strict liability, for example, or a general intent crime. And I guess my last question is, if we conclude that this is a general intent crime, do your clients lose?
No, they do not, because if this is a general intent crime, the knowledge element, the knowledge requirement of scienter applies to each element. The first element being the transport of the cigarettes, the second element being contrary to this act. That's an element. it's a element of the crime which is non-jurisdictional and does not enhance penalty, and therefore is clearly an element of the crime.
I can't help but just follow up with it and just say, so as long as your clients remain ignorant of the requirements of the act, then they're okay?
Then we get into a different issue, Your Honor, whether or not they're intentionally doing that and willfully blind, et cetera, then that's a different situation. But whether the knowing requirement applies is, I think, a different issue. I think the court's jumping to down the road. All we want to have this court, or what we're suggesting this court must do based on its own holdings and the U.S. Supreme Court, is to say that element the knowing element applies based on the recent legislative revisions.
So we're clear, you want us to conclude that they have to know that their actions in transporting cigarettes without a license, they have to not only know that they're transporting cigarettes and know that they don't have a license, but they have to also know that doing those two things is contrary to this statute or contrary to the law more generally. Is that right?
Yes, because they don't have knowledge of their status that is the contrary to this act.
They have knowledge of their status as not having a license, right?
Yes, they have. No, they did not have a license. They don't have knowledge that they have knowledge that they don't have a license. Correct. Yeah. They know they don't
have a license, right?
But they don't even know that they're supposed to have a license. There's no proof showing that they had knowledge that they were acting contrary to this act, because they don't even know that they're supposed to have a license, because there's not even been a showing that my client even knew that he was hauling tobacco products. But it's not ignorance of law, Your Honor. It's not ignorance of law. We're not saying they didn't know about this. It's just that the knowledge does not, he doesn't have knowledge of his necessary status, that he needs to have a license and that he's acting without that license.
You're confusing me now. If he knows he's transporting cigarettes and he knows he doesn't have a license, your position is, unless he also knows that doing that violates this statute, that he's okay, right? He can't be criminally liable for that, right?
If he knows he's transporting cigarettes and he knows he's supposed to have a license.
Oh, he knows he doesn't have a license. Those two things. Yeah, I think you're.
Well, that's an inference as to whether or not he has knowledge or doesn't have knowledge. That can be one of the inferences, but that doesn't affect the determination whether the knowledge requirement applies to that element of contrary to this act. That's all I can say.
If I may just add a little something to this argument.
Go ahead, Mr. Saman.
Thank you. I think the other issue we need to look at is whether these individuals fit within the definition of transporter as outlined not only in the definition set forth in subsection Y, but in the statute as a whole. And if you look at the statute as a whole, and if the clients were to have been in a situation to review the statute, there's nothing in the statute that would say employees of wholesalers, or in this case, the Indian tribe, qualify for a license. Everything in the statute, actually the statute modifies the definition that's set forth in transporter. And everything in the statute talks about a business in the transportation of cigarettes, an ongoing activity, not simply an employee that's carrying out a function, however often that may be, for his employer. And in this case, and if we look at the application that was put forth by the Department of Treasury, clearly it says a business.
Mr. Simkus, I'm sorry, Mr. Saman, I'm going to move on to Mr. Simkus because we have used well over your time, but I appreciate that contribution. Mr. Simkus, you may proceed. Simkus, I apologize.
That's all right. Thank you, Your Honor. I take it everyone can hear me okay.
We can.
Thank you. Good morning, Your Honors, and may it please the court. Assisting Attorney General Scott Shimkus appearing on behalf of the people. The plain language of the Tobacco Products Tax Act makes clear that all parties involved in the manufacturing, distribution, and transportation of tobacco, including both businesses and individuals, must be licensed to do so. Indeed, tobacco is one of the most heavily regulated commodities in our country, not unlike firearms or alcohol. And cases like this one obviate the need for such regulation. Defendants Davis and Magnant were not caught transporting just a few packs or even a few cartons of cigarettes. They were pulling a trailer with nearly 700,000 cigarettes. Yet they did not have a license to do so, and they were charged accordingly under the Tpta. So in this regard, this court has asked 3 questions, and we have 3 answers. First, that the Tpta does, in fact, hold individual transporters, including non-supervisory employees, such as the defendants in this case, responsible for the lawful transportation of tobacco. Second, that the Tpta provides constitutionally fair notice of such individual responsibility, given the statute's plain language. And third, that the people must prove only that the individual transporters knew they were transporting 3,000 or more cigarettes, not whether they knew they needed a license to do so. Your Honors, this law is really no different than Michigan laws that require a person to be licensed to, for instance, carry a concealed firearm or transport flammable liquids or hazardous waste, and criminalizes the failure to be licensed without regard to whether the offender knew of the licensing obligation. And for these reasons, we ask this court to deny leave or to otherwise affirm the Court of Appeals decision below. Now, opposing counsel started and especially talked about the knowledge requirement here, so I will start there as well. And opposing counsel touched on the Rahafe decision or Rafe decision from the U.S. Supreme Court. But there's a distinct difference there. In order to even apply Rahafe, we have to look at whether the statute in Rahafe and the statute at issue here are even comparable, because that was a direct appeal criminal case from a federal crime, not a state crime, and certainly not a Michigan crime. So looking at the statute in Rahafe, as Justice Viviano pointed out, that had an explicit knowingly requirement. It said whoever knowingly violates subsection G in that case would be guilty of a 10-year offense. Because the word knowingly was present in the statute, the Supreme Court could look at its grammatical context and figure out to which elements the knowingly applied. And in that case, the court decided and reasoned that the knowingly modified the word violates, because that's the word that immediately came after knowingly. And then they had to look at what is the object of violates. The object was the defendant's status. It was the violation of subsection G. But here we don't have that grammatical context because the word knowingly is not in the statute. Now, to be clear, we're not advocating that this is, in fact, a strict liability statute. We've pointed that out in our briefing. We've never maintained that position. We agree that knowingly should apply to part of the statute here, and because it should apply to at least part of the statute, it's necessarily not an offense of strict liability. But here, even if we were to put the word knowingly in, let's say, the same position that counsel points out is present in subsection 11 of 428, where it says a person knowingly possesses, transports, acquires, along those lines. Knowingly would modify the word transports or possesses in this case. And then we have to look at what is the direct object of transports or possesses. And that is not contrary to this act. The direct object of that is what is possessed, what is transported, and that is 3,000 cigarettes. And for those reasons, that's the only requirement that the prosecution has to show for knowingly, that they knew they were transporting 3,000 or more cigarettes. And in this case, that almost can't be an issue, or at least it's relatively easily proved given the sheer quantity of cigarettes that the defendants were transporting in this case. We're not talking about even the statutory minimum of 3,000. We're talking about over 10 times that. We're talking about many, many, many boxes of cigarettes. We're talking about 56 boxes to be specific that filled roughly 2/3 of a snowmobile trailer in this case.
Mr. Shimkus, let me interrupt you and see who has questions, and if nobody does, we'll come back, okay?
Absolutely.
Justice Bernstein.
Yes, counsel. Good afternoon and happy New Year. A quick question. I'm just going to ask you kind of more of a hypothetical type of a situation. I just wanted to be curious, what if the officers, the troopers had pulled over the truck and the individuals in the truck, when asked, what are you hauling, had said, you know, I don't know. I'm uncertain. I don't have any knowledge. I'm a professional truck driver. And, you know, I went to the location, I picked up the materials, and I'm told where to go. Would that change the nature and scope of this case?
Your Honor, no, it would not, because another provision of the Tpta specifies that a transporter, an individual truck driver, has to have a permit or a license for that transport that they have. That is MCL 205.426 subsection 8. And that's providing notice that they need a transporter license, not only that they need the license, but that they must have it on their person or at least in their vehicle to present to the trooper. And furthermore, Your Honor, the section just above that, subsection 7 of the same provision, states that the driver must have an invoice or bill of lading describing themselves, their vehicle, and specifically their haul. The quantity of tobacco, the brand of tobacco, they must have that information with them so that if they're pulled over for whatever reason it might be, they can provide that information to the trooper, specifically under the Tpta. So there are provisions that tell the drivers they have a level of personal responsibility. They have an obligation to get that information to be able to provide it to the trooper. So it wouldn't necessarily change here. It just, we're looking at perhaps a different section of the same statute.
Okay, thank you, counsel.
Justice Clement,
No questions. Thank you.
Justice Kavanaugh,
No questions.
Justice Welch.
Yes, thank you. Mr. Shimkus, a follow-up on sort of using the hypothetical scenarios. What if the employee actually did their due diligence, asked their really did know about the statute, and was told by their employer that everything is legit, we've got proper stamps, you don't have to worry about it? What then? Do they still fall under the statute?
So, Your Honor, the answer to that question is yes. They would still fall under the statute because, again, the statute does put a level of personal responsibility on the driver. They must have this information. Even if their employer were to tell them, don't worry, everything's all right, you're covered, it's still on the driver to say, okay, that's great. Where's the paperwork? Because I know I have to have that. But even if that were the case, even if the employer had that information, the statute essentially provides a sort of double protection here, because it's covering both the employers and the employees. We know the statute defines person, for instance, as an individual, and that the transporter uses the definition, the specific definition here of person. So even if the employer has all of that information, there is still a level of responsibility on the driver to also have that information. Although at that point, if the employer is, let's say, for instance, lying, it is possible that the employer could be prosecuted and the driver would not be prosecuted, but the statute provides that both could be subject to criminal liability for their actions.
Thank you. No further questions.
Mr. Shimkus, I have a question. How is a layperson supposed to look at the Tpta and understand the licensure requirements for transporters? Like, say I want to get into the transporting business. I mean, how is a layperson supposed to understand what the requirements are? And then how does that relate to what we should think about what the elements are of this crime?
So, Your Honor, the simple answer, at least to the first question, is the plain language of the statute. The drivers have a level of responsibility to know what they're getting into, essentially, because this is such a heavily regulated area. It would be the same if they were getting into, as I mentioned earlier, let's say flammable liquids or hazardous waste or alcohol or firearms. It's something that they should at least be on notice that they should be inquiring into. And because the statute is so plainly laid out, we have the violation for which the defendants were charged in this case, subsection 3 of section 428. That points us to contrary to this act. What does that mean? So we look at 423 sub 1. It says, well, if you're a transporter, you have to have a license. Well, what does transporter mean? Then we go to the definitions and so on. And that leads us to individual liability. So they know, looking at the statute, it's admittedly a complicated statute. There's no denying that. But that doesn't change the clarity of the plain language at issue here. And then I believe your second question went to the elements of the offense. So in terms of the elements of the offense here, it's not necessary that, again, we go back to the knowledge portion here, that even if we follow Rehafe, the knowledge requirement is only for the 3,000 or more cigarettes and the transportation of them. It's not applying to contrary to this act, because the knowingly, even if we insert knowingly, again, let's say in the same place as subsection 11, it's not modifying contrary to this act. For instance, the same thing if we look at a prosecution for carrying a concealed weapon. There is a license requirement for carrying a concealed weapon, but the prosecution is not required to prove that the person knew they had to have a license, only that they were carrying the weapon. And if they had a license, or if they were under a mistaken belief that they had a license or something along those lines, they could assert that as an affirmative defense, but it's not an element that the prosecution has to prove to convict them of carrying a concealed weapon.
Okay, thank you, counsel. Justice Zara.
Questions? Thank you.
Justice Viviano.
Counsel, I just have one question. How should we think about the fact that the application is supposed to be made on a form prescribed by the Department of Treasury, and that the form appears to limit eligibility for transporter's license to businesses? That's the argument that defendant raises. I guess I'm looking at the form now on my computer screen, but isn't that confusing to individuals, the notion of whether they should understand that they're subject to the act and they need to get a license in their individual capacity? Is this form not confusing to them?
So, Your Honor, my best answer to that is that the form at the time, at least, wasn't necessarily reflective of the statutes. The statutes have always provided for individual liability and the need for an individual license, even if the form at the time didn't necessarily make that clear, I suppose. And the form has since been updated. And I know the defense points to that as, well, that's a reason that Your Honor should agree with the defense, because the department has changed their tune or something along those lines. But that's not necessarily the case. We know, even in the lower court opinion that we see here from the Court of Appeals, that even if we have agency interpretations that might be not entirely in line, I suppose, with the statute, that doesn't change the statutory language. That doesn't change the obligation. In this case, it would be on the drivers to know that they needed an individual license. And again, this goes to more evidence in the record that really, when we're talking about transporting tobacco, it's much more common, much more typical to use a common carrier, because those common carriers are federally regulated. And so it's pretty uncommon for an individual transporter to even get a license. But if they are going to choose to individually transport and not use a common carrier, the statute does make it clear that they need to get a license.
I guess the problem is, if you're an uncommon carrier, to use your terminology, if you're an individual, the statute says, I don't disagree with you. It appears to indicate that you have to get a license as an individual, but it says you have to do it on the form prescribed by the department. And then if you migrate over to apparently to the earlier version of this form on the department's website, doesn't that sort of bring you to a dead end if you're one of our citizens and you're trying to figure out what you need to do to conform your conduct to the law?
Your Honor, I would say at that point,
what are you supposed to, in other words, what are you supposed to do? Do you white out the form? Do you create your own form? What is it? Aren't you in a cul-de-sac?
Your Honor, there still would be, again, I think I'll repeat that there would be a personal obligation on the driver. So whether that is inquiring.
I agree with you, but what do you do? you're a John Q citizen. You understand you have this obligation to get a license on the form. You're trying to do what you need to do, but doesn't it further confuse you when you go to the department's website? And I guess here the distinction here, and I don't disagree with you. You know, the guidance, we're not restrained by the guidance of the agency necessarily when it's inconsistent with the law. But here the statute says it has to be done on this form. It doesn't say you can do it on this form or you can do it on the back of a napkin or a postcard or some other way. You have to do it on the department's form.
Correct, Your Honor. And what I was about to say is that it might require the driver to do a further inquiry. It might require them to talk to the department or talk to their employer, perhaps. It might require them to do a little bit more in accordance with the statute, even if the form itself might be, I guess to use your word, confusing. If they know based on the statute that they do have some personal obligation here, then they might need to do some further inquiry based on the form.
Okay, thank you, counsel.
Does anyone have any follow-up questions for Mr. Shimkus? Thank you, counsel. And Mr. Pitsatowski and Mr. Saman, we went over your time, so we are not going to have any further rebuttal. This case will be submitted. Thank you all for your presentations.